India Legal, stories that count.
Hello and welcome to this week's edition of India Legal magazine. I'll go straight into the cover story, which deals this week with the question of pendency. Now, pendency is a fancy word, but it's a millstone in the neck of the judicial system. With 45 million cases and counting, the heavy caseload has made time-bound justice a mirage. Though solutions abound, the road to end pendency is not an easy one. Bulk of the cases have to be resolved through traditional heavy-duty legal procedures, and a robust judicial workforce has no option but to bite the bullet. The back-breaking backlog of cases, continuously harnessed until the Indian judiciary, is a bane on the justice delivery system. The Indian judiciary is facing an ever-increasing caseload and a large number of vacancies at every level. The hike in pendency has often been ascribed to the fact that there are not adequate number of judges. In its 120th report of 1987, the Law Commission stated that 50 judges are required per 10 lakh of population. Currently, for every 10 lakh, there are only 17 judges at different levels of the judiciary. If the 50 target is accepted, this works out to an additional 98,000 judges. Hence, it's a natural conclusion that the number of judges in courts needs to be increased. It is argued that if the vacancies in courts are filled, a pendency could be curtailed and made justice to make the justice delivery system efficient. Shailesh Gandhi, former Central Information Commissioner and RTI activist, has done research on pendency-related issues. He's come to some conclusions and has proposed innovative solutions. Gandhi says, and I quote him, "Our study on the courts was done using data from the Supreme Court website for the period 2006 to 2017. This showed that the average increase in pendency was about 2.5% per year. The sanctioned number of judges was about 18 per 10 lakh. But the average vacancy in judicial positions was over 21%. Now, if the vacancy had been filled, the pendency should have gone down each year by over 17% per year. We do not need 50 judges per 10 lakh people." The resultant arithmetic indicates a negative balance, and each year the backlog would reduce. The system would also be able to deal with some increases in the new cases. By incrementally increasing the number of judges and reworking the judicial work hours and shifts, a considerable breakthrough can be achieved. Gandhi proposes, and I quote him again, the only shortfall could be of courtrooms. If we expect there would be no courtrooms for the full complement of judges, about 6,000 courtrooms could function in 2 shifts, as suggested by Justice Dabolkar. Most of the connected cases, civil and criminal, take 2 to 5 years for disposal. However, Justice Narendra Purushottam Chapalgaonkar, former Judge Bombay High Court, has a slightly different take on the judges and the pendency. Justice Chapalgaonkar says, and I quote him now, "It is true that if the number of judges is increased, case disposal rates will also increase. However, it's a myth that only by increasing the number of judges can be reduced the caseload. The case disposal rate is certainly not a direct function of the judge's numerical strength. We need good judges who are strong in their homework, and they must be given backup support like library and staff. Young people should join the judicial ranks, and the more competent of judges with expertise and specialized knowledge in domain files should be given tenure extensions." Normally, the judiciary is not proactive in initiating the selection process of judges. This results in a lag between the vacancy and the recruitment. The resultant lag that I'm talking about, actually the process of selection of judges must be started 12 months before the anticipated retirement of a judge. And the collegium recommendation must be sent to the government 3 months before the vacancy occurs. There should be a similar approach for subordinate judges, ensuring that the selection process is finished in advance. Gandhi, and I quote him again, says that the selection of judges for the higher judiciary is done by the Supreme Court collegium, which often selects judges after 1 or 2 years of vacancy arising. The responsibility of selecting judges for the subordinate judiciary is with the high courts and the state governments. The Chief Justices should accept the responsibility of ensuring less than 5% vacancies and be held accountable for this. Another significant move has been in the direction of adopting digital solutions to aid the disposal of cases. The Supreme Court has been implementing the e-courts mission mode project across the country, which is currently in phase 2. As a result of this mission, a number of computerized district and subordinate courts had increased from 13,672 to 16,845 between 2014 and 2020. The phase 3 envisions an infrastructure for the judicial system that is natively digital. However, as hybrid system of hearing is currently best suited for the hearings, the COVID emergency plan has already laid the ground for hybrid processes. Chief Justice Ramanna had already identified procedural barriers as roadblocks in access to justice. He said that the simplification of procedures and a greater thrust on alternative dispute resolution methods should be part of the game plan. While the Code of Civil Procedure was amended in 2001 and 2002, there is still scope for improving orders issued under the Code for issues like written statements, costs, examination of parties, framing issues, evidence on affidavits, and ex parte injunctions. Since 2/3 of the backlog consists of criminal cases, amendments to the Criminal Procedure and Indian Evidence Act are also long overdue. This backlog is equally alarming for both civil and criminal cases. The case ratio is 2:5. Currently, out of the 27.5 million cases pending in trial courts in the country, only about 83 lakhs are civil cases and 192 lakhs are criminal cases. Most of the contested cases, civil and criminal, take 2 to 5 years for disposal. In some states and in some category of cases, the period of pendency may even go up to 10 years. There are problems with lack of pretrial hearings, service of summons, delays in supplying copies to the accused, delays in framing charges, repeated adjournments, non-availability of witnesses, sometimes non-availability of judges suddenly going on vacation without warning, lack of public prosecutors, etc. The list is endless. Recently, the union government had approved the continuation of more than 1,000 fast-track special courts as centrally sponsored scheme for 2 years, April 2021 to March 2023. But fast-track special courts are no panacea for the quick delivery of justice. I want to quote Justice Chapalgaonkar again. Alternative dispute resolution has now become time-bound due to relevant amendments in the law. However, the mufassil areas, in the rural areas and in the smaller towns, it is still costly compared to what the apex court wants. The appeal against arbitration awards are required to be placed before the district judge. Hence, the chances of cases lingering in district court for a long time is still there. A quick disposal mechanism of appeals needs to be developed and adopted. Solving legal disputes through the alternative disputes resolution, sometimes known as ADR, is also the need of the hour. Arbitration and mediation are methods to resolve conflicts without going through the arduous legal channels. If adopted correctly, this could be part of the solution and go some ways in reducing the pendency of specific cases, but a lot more needs to be done. This is Inderjit Badhwar. Until next time.
India Legal, stories that count.